Hello everyone, today we are going to solve a few most important MCQs on administrative law. So those who are preparing for All India Bar examination this year, this video lecture will be very helpful for you all. Hey everyone, my name is Sangeeta. Welcome back to this channel, Be Legally Aware. So without any further delay, let's start today's session. So let's see the first question. So the first question is about administrative law. Administrative law forms part of which of the following? Let's see the options. Options are international law, option B common law, option C public law, and option D private law. So in this case the correct option would be our option C, that means public law. That means administrative law forms the part of which law? Public law. So in this case the correct option would be our option C. Okay, so now moving to next question. So the next question is our Dines versus Grand Junction Canal was considered as a classic example of the application of the rule against which of the following? Okay, let's see the options. Options are personal bias, option B official bias, option C pecuniary bias, and option D judicial obstinacy. So in this case the correct option would be our option C. That means Dines versus Grand Junction Canal was considered as a classic example of the application of the rule against the pecuniary bias. So in this case the correct option would be our option C. Okay, so now moving to next question. So the next question is our intra-vires means which of the following? Let's see the options. Options are the person has a legal standing to bring the matter to the court, and option B the person may act on behalf of another, option C the administrator must act within the boundaries of the power granted to him or her, and the last option is option D, that is a person cannot sue in his or her own name. So in this case the correct option would be option C. That means intra-vires means the administrator must act within the boundaries of the powers granted to him or her. So in this case the correct option would be option C. Okay, so intra-vires means within the power, within the power. So in this case the correct option would be option C. Okay, so now moving to next question. So the next question is our a delegated legislation may be held valid on the ground of which of the following? So let's see the options. Options are Parent Act is unconstitutional, option B malafide, that is bad faith, option C where delegated legislation is unconstitutional, and option D where Parent Act delegates incidental legislative functions. So in this case the correct option would be our option D. That means when the Parent Act delegates incidental legislative functions. So in this case the correct option would be our option D. So now moving to next question. So the next question is which of the following is not a form of the abuse of powers by the administrator? So let's see the options. Options are the exercise of power with the unauthorized or ulterior motive, option B the exercise power using an unauthorized procedure, option C the exercise of power in a reasonable and justifiable manner, and in this case the correct option would be option C. That means the exercise of power in a reasonable and justifiable manner. So in this case the correct option would be option C. Okay, so now moving to next question. So the next question is our which of the following statements is true in respect of AIBE decade's formulation of the rule of law? The options are the rule of law is synonymous with social justice, option B the rule of law is based on supremacy of law over arbitrary discretionary power, equal subjection to the law, and the origins of the constitutional in private law, and option D the rule of law is C the rule of law is purely a political concept, option D the separation of power is part of the rule of law. So in this case the correct option would be option B. That means the rule of law is based on the supremacy of law over arbitrary and wide discretionary power, equal subjection to the law, and the origins of constitutional law in private law. So in this case the correct option would be option B. Okay, so now moving to next question. So the next question is our French legal system known as Let's see the options. Options are Droit administrative, option B counciled ETAT, option C judiciary, and option D none of the above. So in this case the correct option would be option A. That means the correct option would be option A, that is Droit administrative. That means French legal system is also known as Droit administrative. So in this case the correct option would be option A. Okay, so now moving to next question. So the next question is our rule of law means. What are the options? Options are supremacy of judiciary, supremacy of law, equality before law, and supremacy of parliament. Option A 1 and 2, option B 3 and 4, option C 2 and 4, and option D 2 and 3. That means rule of law means both supremacy of law and number 3 equality before law. So in this case the correct option will be option D. That means law means both supremacy of law and equality before law. So in this case the correct option would be option D. Okay, so now moving to next question. Next question is match list 1 and list 2. Match list 1 and list 2 and select the correct answer using the codes given below. Let's see the options. Let's see the list 1 and list 2. Number A, abuse of discretion. Option B, equality before law. Option C, delegated legislation, and option D, separation of power. So delegated legislation would be ultra vires, and separation of power would be check and balance. Abuse of discretion would be lack of power, and equality before law would be rule of law. Okay, so that option would be option A. Okay, so now moving to next question. So the next question is writ of mandamus. Writ of mandamus may be issued to which of the following? Let's see the options. Options are compel the judicial or quasi-judicial authorities only to act. Option B, compel the authority to act. Option C, compel the authority how to act. Option D, compel a private person. So in this case the correct option would be our option B, that means compel the authority to act. That means writ of mandamus may be issued to an authority to act. So in this case the correct option would be option B. So now to next question. The doctrine of vicarious liability is based on which of the following? Options are the options. Options are odi ultram partem, respondent superior. Option C, quasi par eliam fecit per se, and the last option is both B and C. So in this case the correct option would be option D. That means both B and C. That means the doctrine of vicarious liability is based on the both respondent superior and qui fecit par eliam fecit per se. Okay, so in this case the correct option would be option D. Okay, so now moving to next question, and this is the last question. So the next question is doctrine of locus standi means which of the following? Options are writ can be filed by any person, power of courts for judicial review. Option C, right of petitioner to file the writ petition, and option D, discretion of administrative authority. So in this case the correct option would be option C. That means doctrine of locus standi means the right of the petitioner to file the writ petition. So in this case the correct option would be option C. Okay, so this is for all today. If you like this lecture, please like this video and please don't forget to subscribe the channel. Till then, take care. Bye bye.